Can I include gambling debts in a Chapter 7 bankruptcy? If you are struggling with gambling debts and considering bankruptcy, you are probably wondering if those debts can be included in a Chapter 7 bankruptcy. Let us break it down to help you understand your options. First, it is important to know that gambling debts are generally considered unsecured debts, just like credit card balances or personal loans. In a Chapter 7 bankruptcy, unsecured debts can usually be discharged, meaning you will not have to pay them back. However, there are some exceptions and considerations you need to be aware of. For instance, if you incurred a large gambling debt recently, it might not be dischargeable. Specifically, if you accumulated a gambling debt for a luxury good or service over $600 within 90 days of filing your bankruptcy petition, or if you took a cash advance over $875 within 70 days of filing, these debts might be presumed non-dischargeable. Another critical point is whether the debt was incurred through false pretenses, false representation, or actual fraud. If the creditor can prove that you had no intention of repaying the debt when you incurred it, the debt may not be dischargeable. For example, if you were unemployed and incurred multiple gambling debts without any attempt to repay them, this could be seen as evidence that you did not intend to repay the debt. The court will look at the individual facts and circumstances of your case. If you have a history of repaying previous gambling debts and had a reasonable belief that you could repay the current debt, even if it was statistically unlikely, you might be able to persuade the court that the debt should be discharged. It is also worth noting that any money you win while gambling during the bankruptcy process will become part of your bankruptcy estate, and your creditors could claim a portion of those winnings to pay off your debts. In summary, yes, you can include gambling debts in a Chapter 7 bankruptcy, but there are specific rules and exceptions to consider. Make sure to wait the required time frames before filing and be honest about your financial situation to avoid any issues with dischargeability. If you are unsure, it is always a good idea to consult with a bankruptcy attorney to get personalized advice.